Thank you so much, Megan, and thank you all for joining us for this webinar. We especially appreciate Cozen O'Connor for sponsoring this conversation because we know that it's incredibly timely with everything that's going on in the field of campus public safety right now. So just want to take some time to introduce our presenters for the day. My name is Abigail Boyer. I'm the Associate Executive Director of Programs here at the Clery Center. Also with us today, we have Gina Maisto-Smith and Leslie Gomez, who are both members of Cozen O'Connor's Institutional Response Group that delivers holistic responses to institutions confronting sexual and gender-based harassment and violence, child abuse, and other forms of misconduct. Both are former career prosecutors at the Philadelphia District Attorney's Office, where they specialize in investigating and prosecuting sexual violence, child abuse, and domestic violence through an integrated family violence sexual unit. We also have with us John DiPaolo, who is also a member at Cozen O'Connor. He counsels colleges, universities, and school systems on compliance with federal civil rights laws, institutional responses to misconduct, and a range of other legal issues. He served in the U.S. Department of Education under President Obama as Deputy General Counsel for Post-Secondary Education and Deputy Assistant Secretary for Policy, Office for Civil Rights. Earlier, he worked in a number of capacities in law and education, including in-house counsel for a private education services company and executive director of a university public school partnership. And last but not least, we have Stephen Healy, who's Chief Executive Officer of Margolis Healy and is a nationally recognized expert on campus public safety, Title IX, and the Clery Act. Stephen was the former Director of Public Safety at Princeton University, past President of the International Association of Campus Law Enforcement Administrators, and he's a consultant, presenter, and trainer who works and speaks on issues related to campus safety and security. So we're so grateful to have all of them today to talk about these very important issues. We always like to start our webinars just as a quick reminder of why we're here and why we do this work. The Clery Center was founded by Howard and Connie Clery, whose daughter Gina unfortunately lost her life when she was raped and murdered on her college campus in 1986. And as many of you are so familiar, the law, the Clery Act, was named after Gene. And the Clery Center continues to work together with college and university communities to create safer campuses. So really our mission is to work with all of you to figure out what resources, what information do you all need to be able to meet both the letter and the spirit of these federal laws that guide our work. There are many different ways in which we do that. One of those methods is through our Clery Center membership, which really brings together all of our programs, resources, training. It packages all of those resources together to help you build your Clery compliance teams and figure out how you can implement this work on your specific campus. We also do quite a bit of work around National Campus Safety Awareness Month, which we just wrapped up at the end of September, but I'm going to talk briefly about some of the resources that we had available this year in case you did not yet have the chance to access them. And certainly we also continue our work through Gene Clery Act training seminars and our role in policy, which our Executive Director, Allison, is on the Hill today testifying and doing that work as we speak. So for National Campus Safety Awareness Month, one of the things our organization always does every year is we create professional development opportunities that are available to colleges and universities for free. We know that September is not always the easiest month to be able to participate in all of that. You all are certainly quite busy, especially at the start of the semester, making sure that you are applying all of the policies and making available all of the resources that you do every day to make your campus safe. But with that in mind, we just wanted to remind you that the National Campus Safety Awareness Month website, nacsam.clerycenter.org, is still available year-round. And on that website, you'll see a number of different resources, many of which are tied into the conversation that we have today, to take some of the tools that you are hearing to do some of the work that we're going to be talking about and to take the first step. So the theme for this year was really helping institutions figure out if I'm looking to tackle something new, whether it's how I organize my prevention programs, whether it's policy development, whether it's composing a team to implement a specific piece, what's the first step and how do we get started? So all of the free webinars and many of the resources that we have available throughout the month really spoke to that issue in particular. So we'd encourage you to visit the website if you haven't already, and we'll make sure that this webinar and all of the associated materials are available on the site as well. So today our goal is to review the recent interim guidance released by the Department of Education related to Title IX enforcement. We're going to take some time to look at a recently released policy from the NCAA, which addresses how institutions respond to incidents of sexual violence and certainly training for individuals involved with athletics, and discuss promising practices in the field in response to Clery and Title IX implementation. I want to reinforce as we get started with the discussion that group discussion board that you see to the right is a space to ask your questions as we go along, and luckily our presenters are incredibly responsive in that they want to make sure that as we're going along, if you have questions relevant to some of the themes that they're talking about, we'll be able to integrate that into the conversation as we move throughout, as well as certainly answer and address some of those questions at the end should we need to. I know that some of you are having some technical glitches, so we're working to get that back up on the screen, but if you continue to have any problems, we'll also remind you that that support and private Q&A can be used to address that. So as we're getting that up and running, one of the things that we also want to remind you is that in the web links and the files section below, as Megan mentioned, there are a number of different resources that you can access, and we'll also use the group discussion pane to revisit or to mention some of the resources that might be relevant that our presenters will reference throughout. Before we dive too far into content, we just want to get a sense of who's in the room, so we are going to move on to a quick poll. You'll notice that on the poll where there are a number of different titles and roles, such as Title IX, General Counsel, Campus Police Security, Residence Life, Greek Life, Athletics, Human Resources, Student Conduct, as well as an other category. So we certainly had a chance to look at the registrant list, but we want to be able to have others get a sense of who's in the room, who your peers are, in addition to those of you that have shared your information in the group discussion, which we really appreciate. So if you could just take a few seconds, we're going to let that poll run for a second or two, and share what your role is at your institution. Great. So it looks like I'm going to leave it open as we are still having some folks answer, but it looks like right now a majority of you are coming from the campus police and safety and Title IX worlds, which makes a lot of sense. I know you all have been asking a lot of questions and have been paying attention to all of the information that's been coming out recently, particularly in relation to Title IX and the information coming from the Office of Civil Rights. So we're going to spend a considerable amount of time talking about some of the things that we've been seeing in the field and our thoughts around that issue. So we can go ahead and close the poll. May have some interest in. And since a lot of you are doing this work, we won't need to spend too much time on the refresher, but one of the things that we always find helpful for any webinar is we know that people come in with different backgrounds and different experiences. So we always want to create a space where everyone's on the same page to start out the conversation so that individuals don't feel as though they're missing information or that they're lagging behind. So just as a reminder, the Clery Act is a federal campus safety law that guides a lot of your policies and procedures in response to campus safety and security. And on the screen, you see the who, where, what, and how of Clery Act reporting. So in terms of information that's being reported under the Clery Act, you have both annual and ongoing requirements. Many of you, I know, were paying a lot of attention to one of those annual pieces, your annual security report that just went out on October 1st. There are a lot of people sending, issuing a sigh of relief now that that information has now been shared. And we really appreciate all of you that have been reaching out and your dedication to not only making sure that that information is compliant, but that it also represents the culture on your campus of support for individuals that may be coming forward and needing to report that an incident occurred. So in terms of who's required to report under the Clery Act, we know that information in that ASR and information submitted to the Department of Education is broader than just reports to campus police or security. It also includes information shared with campus security authorities, which can be other individuals with a security function, but not within campus police or security. It can be anyone that the institution designates as someone to whom to report crimes. And it can also be anyone with significant responsibility for student and campus activities. And I know that Stephen's going to be talking more about the role of campus security authorities later in the webinar. But just remembering that where we capture information for Clery purposes comes from both campus security authorities and local law enforcement. Clery is guided by specific geography in terms of what information is captured within your Clery statistics, but we also like to reinforce that that doesn't limit what institutions provide in terms of support. So a good example is for sexual assault, domestic violence, dating violence, and stalking, there may be incidents within your community that won't be reflected within your statistics if it occurred in a private residence, but you're still providing resources and options as required by Clery to that individual. And I'm sure that that will be addressed more as we continue this conversation. And then just as a broad reminder as we're going into the conversation, those ongoing requirements really are the heart of the work that you do under Clery. So the annual security report is just one document, one resource that you put out to members of your community as well as prospective students and employees. But you also have ongoing efforts that you do in terms of how you implement your policies every single day, the information that you share if there is an incident that could impact that's a current or ongoing threat or an immediate threat to your campus community via information that you share in timely warnings, emergency notification, and the daily crime log, as well as I just referenced, those rights and options that you provide on a regular basis to individuals coming forward and sharing reports of sexual assault, domestic violence, dating violence, and stalking. And then the U.S. Department of Education Clery Compliance Team enforces Clery requirements. And one of the reasons we like to make that distinction is because although both Clery and Title IX go through U.S. Department of Education enforcement, they are two separate entities that enforce these incidents. So as you see on the Title IX refresher slide, the U.S. Department of Education Office for Civil Rights enforces Title IX, whereas the Clery Compliance Team enforces Clery. You'll also notice on our Title IX refresher slide, and we'll be talking more in detail about all of these areas, that who's required to report, although Title IX and Clery intersect, there are some differences in both the function of both of these laws as well as in how they're applied. So under Title IX, the individuals responsible for reporting are responsible employees, and Gina and Leslie will be talking about the role of these individuals more throughout the webinar. Where is in connection with an education program or activity, so it's not guided by those same Clery geography that we see with Clery Act reporting. And the what is how is that although Clery is a consumer protection, consumer information law, Title IX is a federal civil rights law that prohibits discrimination on the basis of sex, which we know includes sexual and gender-based harassment and violence, sexual harassment, sexual assault. And so I'm not going to spend too much time because a good bulk of our conversation today is really going to be around these requirements and how institutions implement Title IX. But a last piece that I'll remind the group is that in addition to enforcement, there's also a civil remedy via the private right of action under Title IX. So with that in mind, I'm going to hand it over to Leslie and Gina, who are going to talk about some of the key resources that we should pay attention to in relation to both of these laws.
Good afternoon, and thank you for joining all of us. I know that Megan shared with you earlier that the resources were available to you. We wanted to take the opportunity to list them in a central space. Obviously, for the Clery Act, we've had some significant changes over the past several years, beginning with the reauthorization of the Violence Against Women Act in 2013, followed by the negotiated rulemaking process, which concluded in October of 2014, and finally the new Clery handbook that came out in June of 2016. While this is not a presentation on the nuances of some of those changes that occurred, we will certainly be talking about some of the VAWA provisions as we move forward through this process, and there have been some new and interesting issues that have arisen even through the 2016 handbook. It's also important, and I know that Stephen will talk to this later, to understand and follow the ED program review findings. There were 2 that were released last week, both of which I think Stephen will be commenting on for us. If we turn to the Title IX resources, you will note that we've included for you 2 resources here with a black line through them. Gina will be talking a little bit more about why they're still on this list and why they technically are no longer on this list. But these are key documents. This is not all of them. There are other documents that are important to consider during this time frame, including the October 26, 2010 letter that discussed gender-based harassment, bullying, and other issues, as well as the retaliation Dear Colleague letter that came out in, I want to say, February of 2014. Gina will correct me on that. But those Dear Colleague letters have not been rescinded. And of note on this particular list, the April 24th, 2015 Dear Colleague letter to Title IX coordinators and the Title IX resource guide has not been rescinded. So we're in a little bit of a patchwork quilt at the moment where there's some guidance that was issued between 2011 and 2017 that is still theoretically good guidance that we have to evaluate how these pieces fit together. And of course, just as we look at the ED program reviews, we can look at the resolution agreements that exist within the Title IX space. Those resolution agreements, again, are not binding. They are not precedential, but they did and do give us insights into how OCR has been interpreting over the past 6 years some of the provisions of that guidance that's now rescinded. We'll talk a little bit more about that concept. Finally, for those of you who are tasked with education and prevention as a Title IX coordinator and looking specifically at the issues within your athletics department, we certainly can understand that there has been new information come forward. This is not law. It's not regulatory guidance, but it is an agency that does have significant impact within how our athletic departments function. And so most recently is the NCAA policy on campus sexual violence, which we will discuss towards the end of our presentation. And with that, I will turn it over to Gina to dive into our new landscape.
Good afternoon, and thank you. As we address the new landscape, what I'd like to signal first, I hope, is a feeling of calm. A feeling of calm because much of what has been said in the 2017 guidance document, significant guidance document, is related to and foundationed upon what was said in the 2001 guidance, and also is integrated with what has been said in the Violence Against Women Act requirements. And that's the first time that we've seen an attempt to integrate the requirements from the Violence Against Women Act, which is federal law. I say this sense of calm because early on, when we were navigating the tsunami of what the Dear Colleague letter and the resulting 2014 Q&A outlined for us as an organization, as institutions across the country, as practitioners, what we were navigating was really the 2001 guidance with some expansion. And so I hope that this gives us some sense of calm that if we were focused originally on the 2001 guidance, this document that was released this year tends to lean heavily and foundation heavily on what's in the 2001 guidance. The 2 documents at issue, to be clear, are the September 22nd, 2017 Dear Colleague letter, which rescinded the April 14th, 2011 Dear Colleague letter, and the April 29th, 2014 Q&A. There is also a September 22nd Q&A on campus sexual misconduct. So there are 2 documents out there from September 22nd of 2017 that are worthy of a close and careful read. Some of the highlights on this interim guidance that we recently received, first and foremost, it has been labeled as a significant guidance document. There are questions and answers that give some information about how OCR will be assessing a school's compliance. Significantly, as I said earlier, it provides that schools should be guided by the 2000 2001 guidance, and there was significant reference back to the 2001 guidance. In listening to the head of OCR, Candace Jackson, and Assistant Secretary of OCR, Candace Jackson, speak to these things after the release of this letter, it was very clear that many of the factors listed in the 2001 guidance document are the factors that will be considered by OCR in analyzing consistency in fairness and consistency in practice and policy. Significantly also, this letter signals a flexibility and significant choice being given to schools. You will see that in the remaining slides and the specifics as we discuss this letter. But significant choice and flexibility being given to schools in terms of their process. And in listening to Candace Jackson speak about this issue, I will share with you that she conveyed that this interim guidance is really a time frame for the department to evaluate how much OCR should be prescriptive and how much schools should be engaged in making choices about these processes and policies. The letter and the guidance document, Q&A, does not expressly address the impact on other guidance documents. However, in listening to Candace Jackson speak about this, she said very clearly with respect to that, we are leaving those guidances in place that we think provide useful guidance, is what was said. So except for the express rescission of the 2011 DCL and the 2014 Q&A, Candace Jackson has stated that they are leaving those guidances in place that, quote, we think provide useful guidance. Further, this Q&A incorporates many of the requirements of the Clery Act as amended by the Violence Against Women Act. As I said earlier, this signals the concepts that will be discussed in future rulemaking, so keep your eye out on that and participation. It also signals, as I said again earlier, great choice in the hands of schools. But the other signal that came through from hearing Candace Jackson speak about these issues is that she is seeking schools to be engaged, constituencies and stakeholders to be engaged as these important decisions are made, and a very openness to listen, not only to individuals, to schools, to higher ed organizations, but to you, practitioners. Further, she signaled a great flexibility in evaluating balancing and choices. One of the things that came through in her remarks are that the public list of schools under investigation is being reconsidered, and you will hear something about that soon. Another area she discussed in reading and looking through what we are going to discuss specifically in the next slides is the analysis of must, should, and may. Must being very clearly used as intentional, meant to emphasize, she said, standards of fairness and impartiality, and looked clearly to the 2001 guidance and where the department felt that they had legal foundation to announce a must. Shoulds were articulated as cautions, red flags, or flags to encourage thought, to encourage institutions to consider generally these suggestions as best practices, and if one of your practices is challenged, to be prepared to articulate why you didn't follow a should, for example. And the last thing I will share with you that didn't quite come through in the words of the document were that this Q&A, this new guidance, will apply to all current pending OCR open matters. And the department is looking very carefully at the open matters consistent with this Q&A. One of the questions that was asked was if a resolution agreement relies on a provision of the 2011 DCL or the 2014 Q&A that were rescinded, what should a school do? And there was very clear direction for that school to reach out to the regional office. Those are some of the very high-level concepts, many of which were articulated, as is on the slide from the document, some of which were learned only from listening to Candace Jackson speak about the implementation of this Q&A and this letter.
In terms of where we're going next, and this is Leslie speaking again, rather than do a chronological walkthrough of the Q&A, we've grouped the concepts into themes, and I'll give you a preview of those themes. The places where we believe that the Q&A adds new procedural requirements, the places where it gives institutional choices that may deviate from the ability to make that choice in 2011 and 2014, the places where it provides guidance that specifically deviates from the 2011 and 2014 guidance, and we'll come back and talk about some of those places, and then the places where it introduces some amorphous concepts that may be harder to define and understand what the standard of enforcement will be in that area. And then finally, the places in the Q&A that are silent or do not address things that did exist in 2011 and 2014 that may in fact be consistent with the 2001 guidance but were expansions in that space. So those are the 5 areas that we'll talk through, recognizing, as Gina framed, that we are in a moment in time where calm is important, staying the course is important, but for all of us practitioners, there certainly is a feeling that this is destabilizing on a number of the key concepts. I wanted to first turn to speak about what I believe are new procedural requirements that have been articulated that did not exist in the 2001 guidance. And if we go back to look at the 2001 guidance, I would suggest that we all brush the dust off of our copies and take an opportunity to read that again with a highlighter, a pen, and lots of little Post-it notes. There is a section in the 2001 guidance that talks about our grievance procedures, and that's section 9. There's also a section that talks specifically about the due process rights of the accused. So this idea that we have to have procedural protections in place that are robust, that comply with whatever due process requirements might be accorded to a respondent through as an employee or as a student at a public or at a private institution. Those are not new issues. What's interesting about the 2001 guidance is it's very high level. It speaks to our procedures having to call for a adequate, reliable, and impartial investigation, that we have to give notice of our procedures, but it doesn't really talk specifically about what those procedures need to look like and what standards of care might exist that we could evaluate if an investigation is adequate or reliable, if we could evaluate whether or not we met our procedural due process requirements or our fairness requirements in a private institution. And so this is a space where what we're seeing in the Q&A identifies a number of key concepts which, quite frankly, are consistent with what we recommend across the country as an effective practice. And again, Gina framed for us the use of the word should earlier. And should was the phrase that Assistant Secretary for Civil Rights Candace Jackson has talked about, a phrase that she meant to use to encourage thought so that we could work with institutions, that it's not a must, it might be a suggestion or a best practice, but that if you don't do a should, there's a concern that it might not be considered a fair process, ultimately, when OCR comes back to enforce and look at what a school has done. However, if we look to the due process case law, and remember for our institutions, it's not just a patchwork quilt that we've outlined between Clery and Title IX, FERPA, other places along that line. There's also state law and, frankly, what our civil courts are doing with our cases. And the due process case law has really focused on notice and a meaningful opportunity to be heard, and then drilling down on what that means. So these provisions that we should provide written notice to the responding party of the allegation is really a great practice to be engaged in. There's more detail in the Q&A. So written notice to the responding party of the allegations constituting a potential violation, including sufficient details and with sufficient time to prepare a response before any initial review. Sufficient details include the identities of the parties, the specific section of the code of conduct, the precise conduct allegedly constituting the violation, and the date and location of the alleged incident. That each party should receive written notice in advance of any interview or hearing with sufficient time. What's two concepts are kind of buried in there. One is the specific notice of the violation itself and the conduct that would reach that violation. So in a case of sexual assault, it's not enough to give the student conduct code violation of sexual assault. We want to be more specific to say by taking advantage of incapacitation or through the use of force or through the use of coercion. Similarly, the names of the parties is one that we have had many schools contact us over the years to ask questions about what does that mean. So I have to give the names of the parties. If I do that, then it's going to chill witnesses from coming forward. And it has long been our belief that both due process as well as the requirements of VAWA, that both parties must have equal and timely access to any information that will be used in a formal or informal disciplinary meeting or proceeding, require that names be shared. Interestingly, this is not a new concept. It was not addressed in 2011 and 2014, but it was squarely addressed in 2001 in the guidance documents under Section 7B on page 17. It says OCR enforces Title IX consistent with the federally protected due process rights of public school students and employees. Thus, for example, if a student who was the only student harassed insists that their name not be revealed and the alleged harasser could not respond to the charges of sexual harassment without that information, in evaluating the school's response, OCR would not expect disciplinary action against an alleged harasser. They then go on to talk about a contrary context where if there's more than one accuser, it may be possible to move forward without sharing the name. But that's a significant statement by OCR, and it's something that I do view as both expanding on what they've said earlier, but offering much greater clarity. Similarly, the requirement that the investigation should result in a written report. This is a new requirement. We've always had to, under Title IX and the guidance documents, share available information. But the written report that includes both inculpatory and exculpatory, note the inclusion of typical criminal law language into our Title IX processes under that space, that we're requiring, and again as an effective practice, that we give the information to the parties in writing. And when I say give, it's the right to inspect under FERPA, not to walk away with the report. And then the last bullet point, the parties should have the opportunity to respond to the report in writing in advance of the decision of responsibility or the decision of responsibility that happens at a live hearing. And OCR was very clear to say that they're not taking a position on what model is the most appropriate. And they've said that all along, that a school can choose any model. But in the new Q&A, they said the decision maker as to any disciplinary sanction imposed after a finding of responsibility may be the same or may be different, and that you may have a hearing, you don't have to have a hearing in terms of that context. The last place that I would note, and we've had some internal discussion about whether or not this is a distinction with or without a difference, is that OCR has now said in the new Q&A that we are explicitly placing the burden on the school, not the parties, to gather information to reach a fair and impartial determination. And while OCR has always said that it is the school's obligation when we receive a complaint to investigate or otherwise determine what occurred, whether or not the party who was harassed asks us to take any action, this is a slight nuance to that I thought was worth calling out, which is placing that burden squarely in the school to gather the evidence, which I suggest means that schools who are asking parties to write their own statements or asking parties to notify their own witnesses and secure their presence at a hearing may be placing a burden on those parties that OCR may look at in the fairness context to suggest that that's a challenging piece. I would note, and Abby has asked me to remind you of this, when we speak about VAWA, VAWA amended Clery, so we are actually talking about the Clery Act. I will tell you that Gina and I continue to speak about VAWA as a distinct moment in time because it changed the school's responsibilities in terms of how we respond, and we are still, I think, in the early years of implementation of how that carries out. I wanted to turn to John for just a moment. John, since joining us at Cozen, has been serving as an interim Title IX coordinator for a very large public school district on the West Coast, and he's been thinking about the practical implications of how you of how you move into integrating some of these pieces.
Thank you, Leslie. Yeah, to me, these are an interesting set of requirements in the context of an administration and an Office for Civil Rights that generally is talking about lessening the regulatory burden on institutions, including in the Title IX space. But here's an area where they've set forth some new requirements, even if they've done it in the language of should, which I think indicates the seriousness with which they're taking the concerns they have about providing a different kind of balance in terms of the ability of respondents to respond to charges and the process that respondents should have. And yeah, so if you're implementing in the in the Title IX coordinator capacity and you're not doing some of these things, it's significant, right? You now have to get up some kind of form where you're getting out the written notice with all these things in it, and again, a report. And you know, it sounds like a pretty fulsome report with exculpatory and inculpatory evidence. So, you know, sort of giving evidence that was on both sides that led to the decision, and you know, the right to respond. I agree with what I think Leslie was saying, that these are things that are, you know, generally elements of fair process anyway. So they shouldn't be offensive to a process that's trying to yield fair results. But it's it is a new level of requirement on these in these areas that is a challenge, just to sort of get it up and running so that you'll do it consistently.
And I want to take a quick second and just throw out a few questions, just because I know you're moving along, and these are in relation to some of what you just shared. So if you wouldn't mind reinforcing, one of the questions we had coming in is whether or not there are any distinctions regarding the name sharing piece for private institutions. And then another related question was, what about situations in which you have a witness that says they have concern for their safety to have identifying information included in the report? So I know you were speaking to some of this, but would you mind just expanding specifically around those areas?
Yeah, why don't I respond to that?
Sure, John, go ahead.
Okay, why don't I respond to the first part of that question on private institutions? I would say the rule is the same. In its 2001 guidance, OCR had a footnote which recognized that constitutional requirements that apply to public institutions don't apply to private institutions, but there's no indication here that these rules are being based on constitutional due process requirements. And although there is an allusion to that in some of the comments, but you know, I think the legitimate basis of these requirements is the Title IX regulatory requirement that a school have equitable grievance procedures. So I think that the legal argument behind these is going to be what's required for equitable procedures, and that regulation, of course, applies to private institutions as well as public.
To expand on that issue, John, you're exactly right, and you did not hear, I know, the Assistant Secretary speak about this, but she said exactly that. This is about Title IX and equitable process, and our view of Title IX and enforcing equitable process. Therefore, these pronouncements apply to both publics and privates equally.
The last place that gives us confidence in this statement is what I framed earlier about the requirements of the Violence Against Women Act, which apply equally to public and private institutions. And those requirements, again, we must provide equal and timely access to any information that will be used in an informal or formal disciplinary meeting or proceeding. Jim Moore has been very clear. He runs the Clery Compliance Division, that he views that to include names. And there is some due process case law out there that also speaks to the issue of the identities being provided. Turning, though, to the other question about regarding the safety of witnesses. This is a space that we're going to talk about in just a few moments, about some guidance that we believe may have been lost from the rescission of the 2014 Q&A, and that's how we do an effective risk assessment and look at safety issues in a meaningful way at an institution, there will always be a balancing that a school will have to progress through as we evaluate what the right institutional response would be. I will tell you that one of the beautiful things that Gina and I have always loved about the 2001 guidance is that it repeatedly refers back to relying upon the good judgment and common sense of educators. In fact, that phrase is in this document. I counted at least 3 times. It says, if harassment has occurred, doing nothing is always the wrong response. However, depending on the circumstances, there may be more than one right way to respond. The important thing is for school employees or officials to pay attention to the school environment and not to hesitate to respond to sexual harassment in the same reasonable, common sense manner as they would to other types of serious misconduct. One of the challenges that has arisen in the advent of the VAWA amendments to the Clery Act is we've now put a construct in place where we're treating dating violence, domestic violence, and sexual assault in the same way, recognizing that the issues around lethality may be very different in dating violence and domestic violence, and that there may be significant concerns around how we care for an individual's privacy and we care for their safety and the safety planning pieces that have to go into that. So our suggestion would be, if we do have a case that comes on campus and we have significant concern for the safety of a victim or a witness, 2 things. 1, likely that's a case that we're going to get to law enforcement because it's going to be beyond our capacity to be able to put the appropriate protective measures in place if we truly think that there's a risk to that individual's health or safety. FERPA allows us to do that as an exception. And 2, there may be circumstances where a school makes a value judgment about whether or not we can move forward and how we can move forward in balancing all those considerations. So this is a space where I will tell you the unsatisfactory lawyer answer of it depends, but generally speaking, that would be, I think, the very rare case and the exception that we'd be looking to protect the identity of a witness. We certainly see that in the criminal justice context sometimes, but it's a very rare thing that occurs.
If I can add to that, if I can add to that just for a second, and this is sort of real-time reading of the new guidance in respect to that question, I do see a notable absence of any specific requirement to disclose the identity of witnesses, and that's at least a little bit meaningful because there is stated a requirement to disclose other things, such as disclose the identities of the parties involved. You know, the fact that it says you have to disclose the parties, it doesn't say the witnesses, and then when it describes the report, it says a written report summarizing the relevant exculpatory and inculpatory evidence. You know, there would at least be an argument there that a summary doesn't have to necessarily name all the witnesses. There's a final sentence that says the reporting and responding parties and appropriate officials must have timely and equal access to any information that will be used during informal and formal disciplinary meetings and hearings. That might yield an argument the other way to the effect of if the decision maker knows the identities of the witnesses, the parties ought to also. So I suppose that leaves me at a place of thinking there are some arguments on either side of that question, and not a clear requirement one way or a clear permission the other way.
In looking to the slide on the screen, of course, there's a may and a choice with respect to the standard of evidence. As it relates to the cross-examination question that came up on the screen, whether the cross-examination right is something that is a must or a should, and if you read the language of the Q&A, it says any process made available to one party in the adjudication procedure should be made equally available to the other party, and there's a list of 4 examples, and included in that list is the right to cross-examine parties and witnesses or to submit questions to be asked of parties and witnesses. So it is in the context of a should. It is in the context if you offer it to one, you're going to offer it to another, and it's in the context of making the decision based on good, reasonable judgment on what is a fair and impartial process. So my advice and guidance to you is if you have made that decision as an institution already, and it is fairly considered and it is fairly applied to both parties, to the extent that you have parties submit questions that would certainly be in line with this guidance, and is certainly in line actually with the earlier guidance, which just discouraged cross-examination and did not require as a must one way or another in doing this.
On the cross-examination question, there is due process case law that has stated that there is the right to cross-examination is not a required element with respect to the notice and meaningful opportunity to be heard.
And then finally, on this slide, the guidance gives schools the opportunity to choose to allow an appeal solely by the responding party or by both parties. And in speaking to this, Candace Jackson said essentially this is not a mandate, and we are not mandating the schools do one or the other. This is a choice. Historically, there is a justification for limiting because historically schools did not provide for an appeal. This question is squarely within what I believe will be discussed in the negotiated rulemaking process. But when asked about it, the Assistant Secretary said it was a question of equitableness. I would encourage you to consider, though, the VAWA requirements as it relates to an appeal and balance those in the context of this discussion.
So moving on to the next concept, we're thinking about places that specifically deviate from the 2011 and 2014 guidance. Interestingly, they are in some aspects deviating from the 2001 guidance as well. And so if we start with the first concept, that we should have procedures that allow for informal resolution, including mediation, that does not involve a full investigation and adjudication in appropriate cases if all parties voluntarily agree. There are some concerns about the word appropriate that we'll come back and talk about in a slide or two. But if we go back to the 2001 guidance, again, at that time, it says grievance procedures may include informal mechanisms if the parties agree to do so. OCR has frequently advised schools that it is not appropriate for a student who's complaining of harassment to be required to work out their problem directly with the individual alleged to have been harassing them, and certainly not without appropriate involvement by a school, perhaps a trained mediator, and that the complainant must be notified of the right to end the informal process at any time and begin the formal stage of the complaint process. Notably, OCR said in 2001, in some cases, such as alleged sexual assault, mediation will not be appropriate even on a voluntary basis. And what we see in the Q&A in this informal resolution space is a little bit broader in terms of how they address that concept. And they note if all parties voluntarily agree to participate in informal resolution, and if a school determines that the particular Title IX complaint is appropriate, the school may facilitate an informal resolution, including mediation, to assist the parties in reaching a voluntary resolution. Now, if we read the two documents together, they may well be holding to that early piece, because in the early language that I read you from 2001, it says in some cases it may not be appropriate, but that's not quite what the message was from Assistant Secretary for Civil Rights comments on the mediation prong last week.
She said expressly mediation may be used in the context of sexual assault, but at the same time, to be fair, she said there are some cases where mediation will not be appropriate, and turn to the use of the word appropriate and turn to then focusing on the balancing factors. So you can see here a theme of coming back to being flexible, causing schools to exercise their judgment and articulate factors that will support a rationale as to which way they will go without giving precise factors to consider.
Yeah, part of the challenge that I'm finding in reading the 2001 guidance document together with the 2017 Q&A is that there are subtle differences that are not explicitly called out. There are places that you think on first blush that the language is similar, and when you dive a little deeper, it's actually not the same as the 2001 guidance. So there are places where the new documents, I think, contradict them in some way. So, for example, moving on to the next point, that states the school, the new guidance on interim measures says that a school may not rely on fixed rules or operating assumptions that favor one party over another, and that in imposing interim measures, we should make every effort to avoid depriving any student of their education. And the view is that that was a subtle nod to a practice of interim suspension, which we think is an absolutely valid and appropriate practice based on articulable facts and standards that a school applies, and with it being tied to a disciplinary process where that could be contested. But this, I think, was meant to counter the view from the 2011 Dear Colleague letter and 2014 guidance that said we should avoid, when putting interim measures in place, we should minimize the burden on the complainant and try to avoid placing that burden there. Notably, if we go back to the 2001 guidance, the language is eerily similar to what we see in 2011. It says it may be appropriate for a school to take interim measures during the investigation of a complaint. It walks through some of those measures, and then it says responsive measures of this type should be designed to minimize as much as possible the burden on the student who was harassed. So that concept of minimizing the burden on the complainant did exist in 2001. I would note that one thing that many schools have been doing is calling out specifically the difference between interim remedial measures, those things that help and assist the complainant, regardless of whether it's tied to a disciplinary process, and interim protective measures, those places where we are taking something from a respondent, being in a class, being in a residence hall, being on campus, and that second level is sort of a higher level of interim measure that's necessarily tied to a disciplinary process. So I guess the most forgiving view of this new provision is simply a statement that it shouldn't be an automatic default one way or the other, that we should not have a fixed rule, and we should always evaluate what are the appropriate facts and factors that we consider as we decide how to move forward with an interim measure.
Yeah, I think Leslie's right in pointing that out. I will say, in listening to the Assistant Secretary talk about this, it was clear to avoid a hard and fast system that focuses on action only on one party. So this was meant to articulate not to have knee-jerk, hard and fast systems in choosing who to burden before there's actually a factual analysis that is going on. So weaving these concepts together, they can be reconciled, but it requires a reading of the 2001 guidance and a reading of the current guidance. And I think fairly, listening to the Assistant Secretary in speaking to this, there is no change in an institution's ability to perform the analysis. The focus was to make thoughtful considerations that consider the imposition on both parties' education predetermination of the facts, and to do that in a fair and balanced way, and to not just have a knee-jerk reaction to one pathway, no matter what the case is about or no matter what the facts are. So it's really tying it to a, again, going back to a fair and equitable assessment of facts is what was intended and may not have been as clear in the writing. And that's what I learned from listening a bit.
Yeah, the challenge, I think, a little bit is that what we expect from our regulator is very clear direction in writing that we can rely on as a standard of care, and having to read the tea leaves a little bit to try and figure out what they meant is confusing. I don't want to spend much time on the concept of a time frame, other than to state that we knew in 2011 it was 60 days. In 2014 they said, well, it was representative. And now they said, really, it's a question about whether or not it's reasonable, and in considering the reasonableness on a time frame, keep in mind the VAWA provisions that state we can extend for good cause as long as we give notice to both parties. Keep in mind also the idea that our time clock for the investigation may actually start at the time that we get a notice of investigation, which is different than the time the complainant first comes forward. So if we have a complainant who comes forward who's not sure how they want to proceed, we spend the time to support them to put remedial measures in place. That may be a period of weeks to months, and as long as we are responding appropriately with interim measures and weighing through our balancing factors and deciding whether or not to move forward, We were successful in writing into policy that was reviewed even by the prior administration of OCR that said that the time frame for investigation could begin at the notice of investigation. And then lastly on time frames, keep in mind the difference between circumstances that are within our control and those that are beyond our control. And I think good cause are those that are perhaps beyond our control. The complexity, witness unavailability, perhaps for example, the hurricane that has recently come through and devastated so much of Florida and other locations. So thinking about those issues, I don't think that we can rest in our laurels on the time frames and say, well, I was really just too busy. I didn't get around to scheduling the hearing yet. I don't have enough panelists. That would not be, to me, things that are reasonable in terms of our delays.
Two things that I just want to flag for informal resolution or in the context of when a complainant requests confidentiality. The balancing factors were referred to very often in the Assistant Secretary's comments and noting to articulate balancing factors that would balance the wishes of the complainant against the risks and safety to the entire community. And that's what's been going on all along. The 2001 guidance suggests that. The Q&A in 2014 actually did a nice job at listing some balancing factors. So in that respect, I think that part of it was the baby thrown out with the bathwater, if you will. But there was a consistent reference to balancing individual wishes of a complainant as being a central consideration against the broader safety risks to the entire community. And that is something that was, I think, squarely addressed by schools, and good work was done by schools across the nation in evaluating those factors. And I think that those factors remain consistent with the 2001 guidance. While there was no nod given to the 2014 Q&A, I would say that those safety factors are viable factors de facto to consider, separate and apart from them being part of the 2014 Q&A.
And before we move on to the next piece, would it be possible for you both to speak just briefly, because you addressed preponderance of the evidence and clear and convincing. Would you be able to just provide a quick overview of some of the distinctions between the two?
John?
Sure, yeah. These are pretty subtle concepts, and some people argue that really it's hard for people to operate in one sphere versus another, and so question whether the different descriptions will make a difference. But what is pretty concrete, I think, about preponderance of the evidence is that it's essentially which side of an argument has the greater weight of evidence, and the greater weight can be very, very little. It could, people talk about 51% versus 49%. The 51% side wins the preponderance of the evidence. Clear and convincing is something beyond that, and I can't actually state that. I'm sure there are some judicial reformulations about what that means, but since we're, a lot of us are familiar also with the criminal concept of beyond a reasonable doubt, it's located in between preponderance and beyond a reasonable doubt, where beyond a reasonable doubt is not that there's no doubt at all, but there's not a doubt that a reasonable person would hold in this matter. And the thing that I think is significant about the space between preponderance and clear and convincing is particularly in Title IX area issues where you do have questions that are one witness versus another witness, the two witnesses being the two parties who are the only people there. Preponderance really doesn't allow you to say that's such a close call that, I just can't say it happened, because if you say this one witness is just a little more credible than the other witness, you have to go with that side has preponderance. Clear and convincing would probably lead to a different outcome in those really close call situations where, you'd say, it's just really close. I've got one person versus another. They're both pretty credible. maybe I could say one seems a little more credible. Maybe there's some little thing supporting more, but it's not enough to get me to. It's not enough to be clear and convincing. So I'm able to say, my determination is that the thing that's alleged didn't happen.
So in speaking to the next slide, there are a few areas that go undefined in the Q&A. One is in the use of informal resolution, and I've spoken to this already, use appropriate processes, and in that to evaluate. And those appropriate processes are based on reason and good judgment and go back to the factors of the 2001 guidance. And I encourage you to read the 2001 guidance, but don't throw out the baby with the bathwater in the list of risk factors that you've evaluated as trained professionals on your campus that help you evaluate whether or not there's broader risk to the safety of the entire campus. As to the aspect of institutional interest, in speaking about, and the Q&A says, we should ensure that institutional interests don't interfere with the impartiality of an investigation. And as it relates to institutional interest, simply the message, at least from the Assistant Secretary, was to follow the evidence without outside influence. And she gave a list of some outside influence things to consider: personalities, status, finances, reputation, stake, and outcome. And while she did not give guidance as to what should schools do to avoid those interests, I think it's implicit when we say that we should make sure that those interests don't interfere with the investigations, to ensure that our investigations are as impartial as reasonably possible within an educational institution. And that brings up the question for me, and those of you that know me and know Leslie know that we've been talking for years about using a regional center to evaluate these cases in the investigative space, because I think it's virtually impossible to extract the perception of institutional interest from an institution's actors that are conducting the investigations. And that's a much more complex conversation, but I throw that out there because I encourage you to read our work on the regional center model, but very clearly the directive is to maintain separation from power, prestige, authority, money, and reputational interest, and protect your investigations to be as fair, thorough, and impartial as possible. Finally, as to training materials, the Q&A states, investigative techniques and approaches and decision-making techniques and approaches may not apply sex stereotypes or generalizations, because in applying them it may violate Title IX. A nuance on this, and the Assistant Secretary stated this in her remarks, is not that we can't be talking and teaching about them, but we have to ensure that those concepts don't bleed into automatic decision-making based on the concept. And the way Leslie and I have taught this for years, and many of you who have been in our trainings have heard us say this, we need to understand the statistics. We need to understand trauma-informed practices. We need to understand the concept of false reports as investigators and as decision makers in the objective based on the evidence or the science or the stat that should fulfill or fill, as a better phrase, our field of vision, that should not be used as a substitute for judgment in the fact-finding portion of our role. So as investigators and adjudicators, we get trained about these things, we populate our field of vision, but we are charged with evaluating each and every case based on the facts in front of us to determine in a trauma-informed way whether or not we have a true or false report or something different. And so we never want to punt to our fact-finding, or in the words of the Assistant Secretary, we don't want to allow sex stereotypes or broad generalizations to bleed in a substitute for careful, thoughtful fact-gathering and fact-finding.
John?
Yeah, so here are a few areas that are not addressed and in a sense lost with the withdrawal of the 2011-2014 guidance. The discussion about the essentially limits on responsible employee reporting responsibilities. The 2001 guidance defines responsible employees. It's very consistent with what came later in terms of 3 different tests you apply and says they have to report. What you see in 2011 and 2014 is an evolution of that concept that took into account the fact that first in 2011 there are people like clergy or counselors whose role as a confidant is essential and really deeply ingrained in our legal tradition and our culture. And then in 2014, a further evolution where there was a recognition that there were also people engaged in supporting particularly victims of sexual violence who went beyond those categories, like people who were volunteering as counselors or conversation partners, even the front desk people at a crisis center, and a recognition that supporting those institutions is critical to supporting victims of sexual violence, which was an interest under Title IX and of OCR, and B, therefore, that the possibility of confidential communication between a complainant or a victim and those people was really important. So that, what I think was a positive development, is no longer there for us, at least certainly not explicitly. Similarly, 2001 guidance talks about the fact that sometimes when someone wants to remain anonymous, the institution may have to move forward with an investigation anyway and may not be able to preserve anonymity. That led to a somewhat one-sided response because the pressure was one-sided, and there were problems also up to the 2011 guidance of institutions that were reflexively and almost universally saying, we're going to investigate every report we get regardless of what the complainant said. And I think there was a very constructive dialogue between OCR and people in the field between 2011 and 2014, where what we were hearing was, that's not always good for complainants. That can be very bad for complainants. And 2014 showed a recognition, in fact, that the autonomy and control of a complainant was of very high value. And so 2014 laid out things to consider and even created a safe harbor of sorts that said, generally, if these fairly extreme factors aren't in place, it's probably appropriate to defer to the wishes of a complainant on this. So again, that is gone, and we're left with the more general direction in the 2001 guidance without at least explicit guidance on where you might respect the anonymity desire of a complainant. As Gina said, that doesn't mean that the factors in 2014 have been, explicitly rejected or discredited, but they're no longer established officially as the guidance. And then finally, the 2014 guidance had direct language about the use of prior sexual history. It said that you can't use it except with regard to the history between the complainant and the respondent. And again, that's an area that is no longer, we don't have that explicit guidance anymore.
As to the guidance on prior sexual history, a question was asked of the Assistant Secretary, and she noted, in part, that is one element of why deep training and expertise is necessary to impartially analyze that information, synthesize it, and determine relevance in these cases. And so it wasn't called out explicitly, but it was a factor that could or should be analyzed in the context of all the evidence in these cases.
And notably in the 2014 Q&A, the statement around how you might consider prior sexual history was not consistent with state law across the country, and OCR allowed in resolution agreements over the years schools to have a more accurate statement about how you might evaluate prior sexual history, which of course is never for propensity or reputation or character, but only if it is a specific material element that could go to prove or disprove an issue at issue in the case. Wrapping on the 2011 guidance because or 2017 guidance, because we certainly want to leave plenty of time for Stephen to talk us through what we're seeing on the Clery front. I just would like to note that there is a little bit of looseness in the language of the Q&A where I think that sentences could be taken out of context and read much more broadly than they are intended. The two places that I would draw your attention to primarily are the idea that if we restrict the ability of either party to discuss the investigation, that could deprive them of their ability to obtain and present evidence or otherwise defend their interests and is likely inequitable. I think that that's something that calls for a much more nuanced conversation and discussion than a one sentence dropped into a guidance document. Similarly, if we look to the next bullet point, this comes from a footnote near the end of the Q&A that's talking specifically about the issue of the standard of evidence. And there's a sentence that says, when a school applies special procedures in sexual misconduct cases, it suggests a discriminatory purpose and should be avoided. That sentence taken out of context seems to suggest that everything that we do under VAWA and Title IX is discriminatory in nature because we're having special procedures, and I certainly don't think that's how it was intended. So I would encourage us to read that in the context of that paragraph and also encourage us to recognize that we do have a federal legal mandate through law to have procedures with appropriate bells and whistles. Not that they have to be different than our other procedures, but that whatever procedures we use have to have all of those Clery procedural requirements set forth in the VAWA amendments. And again, I don't think that OCR was trying to say we have to import all of those issues into our student contact processes across the board, student conduct processes. So again, a place where there's some inartful language that perhaps wasn't thought through to what the natural and logical consequence or the full intent of that language would be. We've already discussed the interim measures piece. Gina is going to wrap us on this document, and then we'll turn to Stephen.
So we've covered this. I just want to encourage everyone as they synthesize all of this information and evaluate their current processes, they have yet another opportunity to look closely at what a fair and impartial process is. Use that time to participate in public notice and comment period. That will help. We've seen a significant shift in the OCR enforcement approach in this administration, and Leslie wants to speak to that just a moment.
Yeah, just one of the things that we have heard was in the past 6 years that OCR was essentially instructing the regional offices to find a violation and keep looking until a violation was found. There was significant authority pulled from the regional offices to make decisions and to work collaboratively with schools. Schools were no longer able to call for technical assistance and guidance, and we are seeing a shift back to the 2001 approach to this, which was OCR always provides the school with actual notice and the opportunity to take appropriate corrective action before issuing a finding of violation. Again, wanting schools to seek voluntary corrective action before pursuing fund termination or other enforcement mechanisms. We have seen that to date already. We have seen OCR processes where early complaint resolution and voluntary resolution are back on the table, and OCR offices are moving very quickly in a much more expedited way to respond to the individual complaints that are raised.
And that turns us to Clery Act enforcement. Stephen.
Great, thank you. That was a fascinating overview. And what's interesting to me is that while things appear to be in great flux with respect to Title IX, I will tell you that it actually appears as if things are settling a little bit on the Clery enforcement side. So let me just talk a little bit about, I think, some confusion in the field or some I guess, inappropriate guidance or comments that that changes in Title IX automatically are going to lead to changes in the Clery Act. And I want to make sure that folks realize that the Clery Act is a federal law that is codified in the regulations. And so any changes with respect to requirements in the Clery Act have to come through statutory modifications. And so what we're seeing in terms of on the enforcement side is really no downtick. So it is not as if this administration came in January and all of a sudden Clery enforcement stopped. In fact, and at least in the cases that we've been involved in, we've actually seen them be more aggressive during the actual program reviews, and I've been involved in a couple of those in the last several months, and again, we see them being very aggressive, more so than I have seen them in the past. So I don't. If you're hearing that Clery Act enforcement is going to slow down, I would ignore those comments because that's not what we're actually seeing. In fact, we're seeing more compliance checks, and if you haven't been the subject of a compliance check, that's basically when something happens on your campus, you get an email from the Department of Education asking about the specifics. And I would just encourage you, if you get one of those emails, well, first of all, make sure that the Department of Ed is not in your spam folder. But if you get one of those emails, to really put forth the appropriate effort to respond to those questions about a particular incident, because it could, lack of an appropriate response could lead to a further review. And then the second thing that we're seeing in terms of the aggressiveness or proactivity on the department, on behalf of the department, is much more focus on the amendments that were added as a result of the reauthorization of the Violence Against Women Act. So when folks think about Clery, I think we still haven't gotten to a point where folks recognize that those VAWA amendments are part of Clery. In fact, when we do training, aside from trying to point out specific requirements, we just focus on this is the Clery Act, because I think trying to approach them as separate documents is not very helpful for institutions to really have a holistic and a comprehensive compliance program. One thing that we have seen and I again had this conversation with Jim Moore, the head of the Clery compliance team, is that they really are trying to be proactive about clearing up the backlog. And just last week, as I think Leslie mentioned, we saw 2 fine letters that were issued. The Occidental fine letter was issued last week, as well as University of St. Thomas, I believe, their fine letter was also issued. And so when you kind of think about how many final program review determinations have been issued thus far in 2017, I believe that Jim Moore is holding to his word that they are trying to clear up some of the backlog. Again, remember, these things take sometimes up to 3 or 4 years. The Occidental review started back in the summer of 2014, and now we're in the fall of 2017, and we've just received the fine letter. So, I think that's important to pay attention to. The other thing that I didn't add to the slide, and this kind of slipped in the Federal Register, is that fines have been increased. We're now at a $54,789 per violation. I think some people have missed that, but it is significant in terms of what you can expect if you undergo a program review and are found in violation. And then the final thing on the enforcement, I think that one thing that we're seeing is that if you are at an institution that experiences some type of critical incident or some type of high-profile situation, it is likely that the Department of Education will be paying attention to you. And so, in other words, if you're at a UVA and you have white supremacists marching through your campus, you might want to expect some attention from the Department of Education. If you're at another institution and you have a high-profile incident involving student-athletes, it's likely that you will get some attention. If you're at a UC Berkeley where you're having protests and demonstrations that sometimes turn violent, you can expect some attention from the Department of Education. So again, it's about having a consistent approach and making sure that you are applying your policies and procedures in an appropriate way. Real quick on these usual suspects, and I apologize for the mislabeling of these items, and let me just get them up here. This is what we are seeing both in the department's enforcement action, the things that they're focusing on, and the issues and the challenges that they are consistently seeing around geography. Campuses, remember, we got a 1-mile rule now, so that means that the department considers any of your buildings or properties that are within a 1-mile radius to be contiguous, and so you have to make sure that your geography determinations and designations are keeping up with the rules. We're still seeing lots of misclassifications of burglaries and sexual sex offenses. Please make sure that you understand what the regulations and definitions say regarding when a crime is considered reported and how it has to be classified. Inadequate policy statements, as you all know, there are 36 plus major policy areas with many sub-discrete areas that you have to address in your ASR, and we were consistently seeing issues and challenges with that. Deficient daily crime logs. Again, there is no excuse for having an inadequate daily crime log that does not meet the requirements of the Clery regulations. So make sure that you're paying attention to those. And then the one issue that we are seeing a lot of is where the Department of Education is saying, okay, you have a policy in your ASR, you have an institutional policy, but how we see you implementing it is problematic because you've basically done the opposite of what you said your policy says you'll do. So a common example of this is what your timely warning policy, as you know, you're required, the institution is required to have a policy on timely warnings. If you are not consistently following what your policy says, the department will find fault in your compliance. So these are things that we believe that definitely are best practices. We're seeing that institutions that are focusing on these 6 items typically have very strong Clery compliance programs. Formally appointing a Clery Act coordinator, again, we've said for many, many years we believe that this is a full-time job, and especially when you consider the additional requirements under VAWA and the need for Clery and Title IX to coexist in a coordinated fashion, you definitely need someone who's paying attention to this on a full-time basis. And that includes having a Clery working group of those key stakeholders around the table on a regular basis, making sure that the policies that we're implementing are being enforced, and that we are addressing all of the discrete requirements of the Clery Act. We believe having a Clery Act compliance policy is a good practice. It ensures that compliance becomes part of the institutional landscape and not just the purview of 1 or 2 individuals stuck, deep in the bowels of some department. And so, having that Clery Act institutional policy, we believe, is a good practice. Your CSAs. Every institution that we have the honor of working with is struggling with this issue around CSAs. And again, on the enforcement side, the Department of Education is focusing on this. You have to identify your campus security authorities. You need to make sure that they know that they are campus security authorities and what you are requiring them to do. And again, a really short down and dirty equation. What we use as a starting point is 20% of your FTE employees. So 20% of your full-time equivalent employees are probably going to be CSAs. And so when you're thinking about your number, if you're not close to that number, then I would suggest that you need to do some rethinking on how you've identified those folks. Your Clery data, reconciling that data on a regular basis, at least on a monthly basis, identifying and tracking your prevention programming so that you, when it is time to publish your annual security report, you are able to plop that information right into your ASR, and then paying attention to those ongoing requirements, and especially around the VAWA provisions. It's especially important that you are able to reconcile what Title IX is saying, what the 2001 letter is saying, what the 2017 Q&A and Interim Guidance is saying, because in some instances it's easy to get lost with what you think you're complying with if you haven't really matrixed all of those requirements. And finally, on timely warnings and emergency notifications, this continues to be a challenge for institutions. You have to have a policy, you have to follow it consistently, and you need to make sure that you're documenting your process for doing so. I'm going to turn it back over to you.
Thank you, Stephen. That was a great set of insights as we navigate this conundrum. I want to end the discussion today with just a brief focus on the newly released NCAA policy on campus sexual assault that was just released in August of 2017. The policy states that each university must attest annually that the athletics department is fully knowledgeable about, integrated in, and compliant with institutional policies and process regarding sexual violence prevention and proper adjudication and resolution. So attest that we're knowledgeable, integrated, and compliant with these policies related to sexual violence, both prevention and adjudication. Further, that the institutional policies and processes and the people who are overseeing it is readily available within the department and provided to student athletes. And then all student athletes, coaches, and staff, we have to attest at institutions that they have all been educated on sexual violence prevention, intervention, and response. This was a good start by the NCAA. I know that they started in 2014 with the sexual violence, addressing sexual violence and interpersonal violence handbook, which was not a requirement or a policy. And then the toolkit in October 16th, outlining some key principles, and this is, as you may all recall, in the aftermath of some very significant attention to athletic policies. But the concepts that were outlined there were leadership, collaboration, compliance, accountability, education, and student-athlete engagement. And then to codify these things, we now see this policy that was just passed. And the only thing I will say on this policy is that while we were required to train all responsible employees and implementers and those that receive, potentially may receive reports of sexual violence or dating violence, domestic violence, and stalking to report, that was always a requirement. The NCAA making this now a policy and part of the teeth is a great start, because until this policy, there was no requirement and no teeth in the compliance requirements. So this is a great start, but it's also something that schools are going to have to pay attention to, because all the training that we've done, whether it be online or in passing or in coaches meetings or staff meetings, may not have been sinking in. So we have to take some steps to integrate and deliberately train for understandable outcomes in this space in order to attest properly. That is now an affirmative responsibility for schools with NCAA sports. So I want to thank the Clery Center for including us on this important conversation to hear our perspective as we all together navigate this. I want to start or end where we started, and that is encouraging calm. I think if you've been thinking about these things over the last 6 or 7 years, you're in good shape. It will give you an opportunity to run this through a discussion, coordination discussion, implementation discussion around your policies, procedures, and practices. And please, as we always encourage, reach out to the Clery Center. You have great support there. Reach out to any one of us at any time. We're happy to share generally what institutions are doing across the country, how they're navigating these issues, how they're wrangling with the complexity of these problems, and how they're coming to fair, informed, and reasonable responses. It would be our pleasure to share that with any one of you on the phone.
So thank you. I'm going to turn it over to Abby to close out.
Thank you so much, Gina, Leslie, Stephen, John. The webinar had so much useful information. There were a lot of great questions coming in. We appreciate your willingness to address them as they were going through. I think there was just one final question, so I want to make sure that we do address that before we jump off the line. And they were just wondering your perspective on whether or not you think that it's likely that the 2001 guidance itself could be rescinded if interim guidance goes through after notice and comment, based on some of the information that you were sharing about the use of mediation and some of the other areas where maybe it's not as consistent.
I think the strength of the engagement in the negotiated rulemaking process will dictate what happens with that guidance. So I encourage anyone with expertise in this area who has lived in this space for decades to be heard, to have their voices heard. I would encourage anyone that has background, expertise, intersectionality with these issues to step up and be heard. Every constituency is important. Every constituency needs to be heard. And the strength of that process will dictate whether or not that 2001 guidance remains. I do think there are things that we pointed out throughout this webinar that aren't squarely aligned with exactly how things are said. It remains to be seen if those things can be reconciled, which they may be able to be reconciled, or if they cannot coexist and therefore require a further rescission. I don't see that right now, and I see great care and comfort being taken, at least by me in analyzing all of this, that the alignment with VAWA and the alignment with the 2001 guidance and commitment to reliance on the 2001 guidance is a good signal that it's leaning toward not rescinding that, but I do believe that the efforts in this rulemaking process will make a difference.
Thank
I
you
would
so
like
much.
to add that
go ahead.
the term they're using, as Gina just said, is rulemaking, which means not issuing guidance after notice and comment, but issuing regulations. And regulations will have the force of law, and they will trump guidance to the extent there's a conflict. So the if that's what they really do, the rulemaking process could even be an opportunity to enshrine elements that are in the 2001 guidance in regulation, which again gives them the force of law and makes them much more durable than they currently are.
Great point,
John. Thank you so much
John.
for sharing. And I think that's such an important reminder as we go to close out the session, in that all of you are attending this webinar certainly because you have interest in these areas. So this is an opportunity that we don't always get to make our voices heard. So we hope that all of you will certainly stay in touch with that process and will lend your voices to it. Again, thank you all for joining us for today's webinar. I just want to reinforce that we did record the webinar, so we'll make that available to all of you, as well as upload it to our National Campus Safety Awareness Month website. Thank you again to all of our presenters. I think this is such a timely conversation and certainly will continue as more information comes out and as that notice and comment period is moving forward. In the meantime, we did put a number of different resources, particularly during Stephen's section, free resources that are available as you're looking to implement Clery pieces and certainly Title IX as well on your campus. Please do feel free to reach out to us, as Gina mentioned earlier, with any questions or concerns that might be coming up for your own campus. Certainly the information provided in this webinar is not the only conversation we all could be having around these issues. And I know that our presenters are so receptive to some of those offline conversations as well. But again, thank you all for joining us and for your participation, not only in this webinar, but throughout National Campus Safety Awareness Month. We hope that you appreciated all of the resources that are available. And please remember to fill out the evaluation that's going to be made available to you all, and it will also launch when we close out this session. That allows us to understand what the current concerns are for all of you, what type of information you're looking for, and then we can create resources to match that. So if you do have the time, please do fill out that evaluation. Let us know what you appreciated, what else you would like to see coming from Clery Center, and we thank you all for your time. Have a great afternoon.